last one.
That's the last one.
I can do it.
Okay, here we go.
See that? Very official self-authenticated. Is that? I'm not sure.
Ready? Court does call the case of the people of the state of Michigan versus Lovely.
Yeah, thank you, and good afternoon, Jonathan Emmons on behalf of the people.
And Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lovely, who stands to my right in court.
Okay, thank you. We're ready to proceed to exam.
Defense is ready.
Yeah, people are ready to proceed in this matter. My understanding is that there's also some kind of a violation hearing. Did you want to do the exam and then kind of do everything all at once, or however?
Yes.
you want to proceed? Perfect.
That's
Not that there's anybody else left. I'm going to call my first witness is going to be Corey Johnson, but I have the officer in charge, Dusty Patel, also here with us today.
all right. Sir, please come forward. Be sworn. All right.
How much for our firm testimony about to give, the truth of the truth and nothing but the truth.
George, I think. All right, go. You may inquire.
Yeah, thank you. And good morning, Mr. John, or good afternoon, Mr. Johnson. Thank you for being here today. Just to kind of get right into it, with the court's permission, I'm going to.
When Andrew Cody walked into court that morning, he expected to plead guilty, take a deal, and walk out with a misdemeanor. But what he didn't expect, what no one expected, was the emotional gut punch that would stop everything in its tracks. A victim's statement, raw and powerful, unraveled months of silence, exposing a disturbing pattern of abuse that left the courtroom frozen. What began as a routine hearing turned into a dramatic reversal that shattered the plea agreement on the spot. This isn't your average court case. This is a breakdown of justice in real time. Cody went from accepting responsibility to suddenly denying everything, forcing the judge to throw out the deal and order a trial. Why did he change? His plea? What did the victim say that rocked the courtroom? And how did the judge respond?
Briefly tell us what the terms of that arrangement were.
Yes, we each had 50-50 custody, joint custody, and then we did our exchanges on Fridays.
Okay, and so is that one parent would drop them off at school, the other parent would then pick them up?
Yes, you complete your week by dropping them off on Friday, and then the other parent would start their week picking them up.
Okay, so I want to fast forward to Thursday of February of 2023. Did anything change regarding that arrangement, that custody arrangement?
Yes, that the first week of February, I would have had custody of my son, and I was contacted by investigating the claims that she had made against me. They turned out to be false. So, I believe it was like the 6th. They contacted me and they said, we're going to go back to normal custody. We advised her to continue like you should be, dropping him off at school, and I would pick him up, et cetera. And that never happened.
Okay.
He was never returned.
So February 6th of 2023, I believe that was a Monday.
Monday or Tuesday.
Okay. You were supposed to have the child on what day? That Friday. So roughly the 3rd. Yeah. I looked at a calendar earlier.
Yeah, I'd have to look at it.
Okay.
Well, hold on. I just want to make sure. On the 3rd would have been your pickup, the beginning of your custody.
Yes.
Okay. Go ahead.
And then that should have terminated with you dropping the child off on the 10th.
Yeah, Friday.
Okay.
Whatever the Fridays were. Got it.
The hearing starts with all the usual ingredients: a guilty plea, a prearranged sentence, and a judge ready to sign off. But listen closely. Cody doesn't sound remorseful. No. He sounds robotic, detached. It's like he's just reciting the words to get it over with, and that's your first red flag. In domestic abuse cases, courts often rely on victim input before finalizing a plea. So when the judge pauses and asks, "Would you like to be heard?" everything changes. This is where the case breaks wide open. You can feel it. Cody thinks he's home free, but the courtroom is about to shift from routine to reckoning.
With a specific destination?
New York, that's all I knew.
Okay. And so did you share those concerns that you had with the defendant at all?
Yes, I told her that would be a violation. We were required to provide an itinerary to front of court, and that never happened.
Okay.
I verified that with Sarah Mazer. She said they hadn't received an itinerary, and that what she provided wasn't appropriate.
Okay. So on the 6th, obviously the child does not return to your care.
Right.
Okay. What happens then on the 7th?
I contacted and law enforcement referenced the issue. A order was filled out and sent to the judge by a friend of court to pick my son up and return him to me. That was signed by Judge O'Brien.
Okay. Did you anticipate that you were going to be able to pick up your child from school that day?
Yeah,
Okay. Did you reach out to the school at all?
I did, and they told me that he hadn't been brought that day.
Okay.
I think he said it was like mental health or something like that.
You obviously didn't excuse him. Okay. Okay.
The victim steps forward, voice trembling, but words sharp as a blade. She doesn't just describe a one-time incident. She outlines a campaign of psychological and physical abuse, lies, isolation, gaslighting, and when she says she was dragged down the stairs and Cody laughed while she screamed, the room goes cold. Even the judge's posture shifts. This isn't misdemeanor territory anymore. This is textbook coercive control. You can see the prosecutor rethinking everything. Suddenly, Cody's little plea deal looks more like a smokescreen to avoid real accountability. The courtroom knows it, and Cody knows. The deal is slipping away.
22nd Circuit Court.
Yeah.
Okay. And that's the order. What was that order informing what was supposed to happen with the child?
I believe, let me read it just to clarify. Says that she's supposed to return to me immediately and not leave the state of Michigan.
Okay. Your Honor, unless there's any objection or voir dire on the issue, I'm going to move to admit People's Proposed Exhibit Number 1.
No objection for purposes of exam.
Exhibit 1 is admitted.
Did the court want to review that?
Yeah, I'll say.
Thank you.
Thank you. Standard order. Okay. Go
Thank
ahead.
you. So now turning your attention then, so that February 7th, that order gets signed. You said that you contacted police. What agency did you contact?
I contacted Northfield Township, and I believe it was a detective that called me. I think he called me back.
Okay.
I sent him that document that I had by email, and then he basically said because of the multi-jurisdictional thing that he was going to forward it.
And just like that, Cody stuns the room. After quietly agreeing to plead guilty, he changes his mind. That's not what happened, he claims. Wait, what? Less than 5 minutes ago, he accepted responsibility. Now he's denying it. This is the kind of 180-degree turn that infuriates judges. It's also the moment Cody reveals his true strategy. Say whatever he needs to until someone pushes back. When the victim pushed back, he panicked. But here's the thing, judges. Don't like games, and this one is about to shut the whole thing down.
Then moving forward to the 13th, that Monday, February 13th, by that point in time, had you received custody of your child? Okay. And it's your understanding that pursuant to the order, the child was supposed to remain in your care until further order of the court. Okay. All right. So then tell me what happens on the 14th of February. Had you, on the 14th of February, so this is Tuesday, had you received custody of your child? Okay. So what did you do, or what happened in terms of that custody arrangement?
And contacted front court and law enforcement and advised them that at that point she wasn't even in Michigan anymore. I
Objection, Your Honor, foundation as to where she was.
I can, if it,
Well, he is, as I understand his statement, whether it's true or not, that's what he's indicating. So there may not be foundation for what it is, and the court will give it whatever weight I give that statement, but I'm going to overrule the objection. Go ahead.
thank you. Go ahead. So I'm sorry, you reached out to friend of the court. You gave them some information.
yes,
What happened as a result of that information?
they submitted another order to the judge. And this was for her, this was terminating her.
Judge Bloom wastes no time. We're not doing this, she says, firm, final, and furious. The plea is withdrawn, the deal revoked, and the case is set for trial. In legal terms, this is a massive shift. Misdemeanor conviction would have meant no jail time, just a fine or probation. But with the deal off, Cody now faces full prosecution and potentially much harsher consequences. All because he couldn't stay consistent under pressure. He gambled with the court's patience and lost. And now, the real fight begins.
A fair and accurate copy of the order that was submitted and signed by Judge O'Brien on the 14th of February of this year.
Yes, it was.
Okay. And unless there's any objection or voir dire on the issue, I'm going to move to admit People's Proposed Exhibit Number 2.
No objection for exam purposes, Judge.
Exhibit 2 is admitted.
All right. So then this order gets signed without telling me what you spoke to. Had you been communicating back and forth with the trooper during this period of time? Okay.
He advised the contact.
Well, don't tell me what he told you. I just want to know if there was still that communication. Okay.
Keep me updated on the status of it.
And had you been communicating with the defendant at all, sending either via Family Wizard or otherwise?
You know, I sent her a message stating that I was contacting the authorities. She didn't return my child.
Did she ever respond in any kind of way? Okay. All right. So then to finish this up, when was the next time you actually received custody of your child?
I called the school Wednesday or Thursday. It was like the 16th, I think, that week when they said he was there, that he had been dropped off. And so I told them that I would be there early, pick him up. And I had the order. I gave them a copy of that. And so they were aware that I had custody of him.
Okay. All right. And that was February, you believe, 16th of 2008.
This isn't the first time a defendant has tried to manipulate the court with half-truths. But Cody's case is a masterclass in what not to do. He tried to minimize the abuse, hoping the legal system wouldn't look too deep. He wanted the benefits of a plea deal without owning the reality of what he did. But once the victim pulled the curtain back, his entire narrative collapsed. In a courtroom, credibility is everything. Once you lose it, you're done, the judge saw. Through him, the prosecutor saw through him. And now, a jury might have to decide who to believe.
During that intervening period of time?
Not allowed to have a phone call with him, just the one.
Okay. You had one phone conversation with him? You recognized his voice? Okay. All right. And I guess, how old is your child? Okay. So he doesn't, he may, I guess, but does he have a phone? Okay. So when you spoke to him,
Yes.
how did you get in contact with him?
We are required to call each other's cell phone.
Okay.
So I call her Alante cell phone.
Okay. And so you called the defendant's cell phone and you were able to speak to the son.
Yeah.
Okay. Thank you. Your Honor, with that, I don't have any other questions for this for this witness.
All right. Before you begin cross-examination, I just want to clarify one thing. The first order, sir, that was signed on by Judge O'Brien on the 7th, there was an indication that the child was to be returned to you, that your understanding was that the child was supposed to be returned and remain in your custody.
Yeah.
The power of the victim's words can't be overstated. She didn't just stop a plea deal, she reframed the entire case. This wasn't just about one incident. It was about fear, manipulation, control, and that's the danger of rushing justice. Sometimes plea deals are offered before the full story is heard, but this time the court listened. And when it did, it gave the victim her voice back. The legal process may be flawed, but this moment, this correction was powerful. A reminder that real accountability takes more than paperwork. It takes truth.
Correct. So you would have the 3rd basically through the 9th,
Yeah.
right? Then the defendant would have the 10th through the 13th. And then your next time would have been the 14th and beyond.
The 17th.
Or the 7th.
Yeah. Whatever that Friday would have been.
Yes, the 17th and beyond, I guess.
Yeah.
So I guess, okay, so here's what I'm trying to figure out. I'm looking at this order, and I'll let you see it again. The order of February 7th. And it indicates that they're ordered to immediately return the minor child to defendant's father custody care and so on. Had that order been effectuated on the 7th, you would have then had the child from the 7th to what, the 10th?
Yeah.
Okay. And that's what didn't happen. Okay.
I didn't get him on the 3rd. I didn't have him. He was never returned. I never got him that week at all.
Right.
Yeah.
So, but what I'm saying is the time, I don't know really what I'm saying. What I'm indicating is you didn't get the child on the 3rd. The order to return the child to you signed the 7th. But if everything were to go back, really, there's like 3 days from the time of the order.
In just a few minutes, this case flipped upside down. Cody walked in expecting a slap on the wrist and walked out facing a full-blown trial. The reason? A victim who spoke up, a judge who listened, and a courtroom that demanded more than just a checkbox plea. If you found this breakdown powerful, disturbing, or eye-opening, make sure to hit that like button. Subscribe for more real courtroom moments and drop a comment.
Your custody. That's not quite correct. On the 7th, is that right?
I believe she's supposed to be returned to me so we can continue our parenting time.
Okay. So, okay, that's something different. That's what I'm trying to figure out. On the 7th, the judge is ordering that the child be returned to you as though this interruption had not occurred. And then it would go back to the normal schedule, right? So from the 10th to the 17th, the defendant would have had primary possession of the child at that point. Not really custody, but possession.
Yeah.
What interrupts that, though, is then the order of the 14th, which then says, and this may have, I just want to be clear on it because it may be what you were talking about, the 14th order. That order doesn't, as I'm reading it, isn't now referencing the parenting time. That order is saying this child goes to the father. That's it until the court says otherwise. Is that your understanding?
Yes.
Okay. Pardon?
That's how Parental explained it to me as well.
I probably did a better job though, right?
You did.
Okay, thank you. All right,
My apologies.
thank you. No, it's okay. All right. Cross-examination.
Judge, if I could just have a moment.
Yeah.
May I retrieve the exhibits?
Happen.
Thank you.